The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Hi, this is Heather Jones, a family law attorney with O'Flaherty Law, and today we're going to do a how-to video on filling out a petition for divorce in Wisconsin with minor children. That's Form FA-4108V. Now, the Wisconsin Circuit Courts have included forms with some general instructions running along the left side of the form, but they can still be a little bit confusing, obviously, especially if it's the first time you've encountered them. So we're going to do a simple walkthrough where I kind of expand on some of the instructions that you were given so that hopefully you can get everything correct the first time and don't have to slow down the proceeding with doing an amended document. So we'll start at the top of the form, and they say enter the name of the county in which you are filing this case. You need to put in your county of residence. Wisconsin has very specific residency requirements, and you need to have lived in the state of Wisconsin for 6 years and the county in which you're filing for 30 days. So it's important that you put your county of residence in the filing spot. And not only that, it's just more convenient. You know, if you live in Outagamie County, why would you file in Dodge? So that just sort of clears that up a little bit. This is a petition. It is not a joint petition. That means only one party to the marriage is filling this out. There are different forms for joint petition, and we'll cover them in another how-to video. But whoever is filing is the petitioner. So in regard to the marriage of you, the person who's filling out this form and filing it with the court, you're the petitioner. First, middle, last name, your current address, shouldn't be a problem. Moving over to the upper right-hand corner of the page, don't put anything there, don't staple it or mark it in any way. This is for the court, the clerk of courts, to put any identifying information, the date that the petition is filed, and where you're at so that we can track the documents and know what goes where. Moving on down this first page, you'll see the title of the document, Petition with Minor Children. And then you'll see two options here, divorce or legal separation. These are two very different things. They just use the same paperwork to begin a divorce proceeding or to ask for a legal separation, but one, they are not interchangeable. They even have different case codes, as you can see here. A legal separation is not a divorce. You'll see a box next to the word amended above the title of the document. That is if you need to refile, if you get additional information or you got something in your original petition wrong, you file an amended petition and you need to make sure that you're clear about the fact that it's amended. Under here is where the clerk of courts will assign you a case number, so you will leave it blank. However, if you're filing an amended petition, you will use the case number that was assigned to you when you filed your original petition. The second signature or identifying block here is for the respondent, the person who is not filing. And a lot of the time, you'll have their current address, but if you don't, it's okay. Sometimes parties separate, and then a few months later, one of them will file for divorce, and they won't really be sure where their spouse is. A lot of times, these people just kind of go off the grid, or they might have an idea through family or friends what town they're in, but they won't have a specific address. Just do the best that you can. You can't, always guarantee that you'll have all the up-to-date, accurate information at this point in the process. So try to get as close as you can to figuring out where your spouse is if they've disappeared on you. Moving on to the second portion of the petition. They want your vital information. They want your date of birth. And then here, as we discussed earlier in the video, they're asking questions about residency. So immediately before filing this petition, I will have lived in this county, the county that you're filing in, for 30 days or more. Also, immediately before filing this petition, I will have lived in the state of Wisconsin for 6 months or more. Then they want to know whether or not you're on active duty as a member of the armed forces of the U.S. or its allies. They relax some requirements for armed forces members, and they also can put a stay on divorce if the other person is in active duty. If they're in a war zone, they might put a pause on the divorce for a while, just to let the other person focus on the fact that they're in active duty in a hostile environment. Then they want to know if you're currently pregnant. Wisconsin presumes paternity of any child born during a marriage. So that would be something to get out there in front of right when you start the proceedings. Are you pregnant? Is it your spouse's child? It's an uncomfortable question. But if you're pregnant, you need to let the court know because specific steps need to be taken to make sure that the process flows correctly and that whatever paperwork needs to be done or hearings that need to be take place. Then you say you're providing the following information about respondent, the person who is not filing. Their date of birth, their residency questions, just as we discussed up above. If you're not sure, you're not sure, but just do the best you can. Again, are they currently on active duty as a member of the armed forces? And if they're pregnant. Once you get A and B out of the way, the court wants to know when you were married. When were you married? Where were you married? The length of your marriage can come into play when the court is determining things like maintenance, but they just want all that specific information laid out right away so that they don't have to spend time asking for it. And then, as we discussed earlier in the video, the court wants to know if you're filing for a divorce or a legal separation. And again, as we said, divorce and legal separation are two very different things. So in Wisconsin is a no-fault divorce state. And the reason you give for a divorce in Wisconsin, it's just this one. The marriage is irretrievably broken. You do get a lot of people who want to talk about why the marriage went bad, if there was infidelity, if someone committed adultery. And the bottom line here is that it's not a reason for divorce in a no-fault divorce state. It used to be back in the day, some states would grant a divorce if you could prove adultery, and they would have evidentiary hearings, and they would have people get up on the stand and testify about the infidelities, but that is not the case anymore. Adultery by one or both spouses is not a legal issue. It's not something that the court is going to spend time listening to testimony about or taking into account in granting a divorce in a no-fault divorce state. This is the one reason here. The marriage is irretrievably broken. Boom, you're done. If for some reason you don't want a divorce at this time and you're asking for a legal separation, this is your opportunity to do so. you'll still be legally married after the legal separation is granted. A lot of people choose to separate instead of divorce because of financial reasons, because of religious reasons, or for some reason they believe it will be easier on their children if they have any. There are many combinations and permutations of why a couple would choose to separate instead of divorce. And the only caution there is that when you're legally separated, you are not legally divorced. Any assets or debts acquired during the separation are still marital. And an example of where that could go bad is if your spouse that you're separated from legally went out and racked up $30,000 worth of credit card debt, it would be considered a marital debt because you're still legally married. On the flip side of that coin, however, is you're still legally married. So if you have children, that could be, an extra layer of protection for them. Or you, as the spouse, could still be on whatever health plan is offered by their employer. And a lot of people consider that a good deal. So again, it's a very personal decision, of course. Just be very careful when you make it because it could have a strong impact on your future financially. So the court then wants to know if you've ever filed for divorce or legal separation from each other in Wisconsin or in any other state. And of course, if you haven't, you just click click no. And it almost looks like they have it reversed here. If you've ever filed for divorce or legal separation from each other, you would click yes and then tell them what's going on. If you haven't, then you haven't. If you did it in Wisconsin and can't remember the specifics, like your case number, you can look it up on the Wisconsin Circuit Court Access Program, which is available online. It's public record. And all you need to do is put your name in and look for a case between you and your spouse. The important thing here is, has it been dismissed? If you filed for a legal separation in Wisconsin and it has not been dismissed, then you don't want to be on this form. You want to be on a different form asking to have your legal separation converted into a divorce proceeding. The next thing you want to do is list whether or not this is your first marriage. If it's not, then you just list your previous marriage, how it ended, when it ended, and where it ended. If you have more than one previous marriage, there's space to put a second marriage here. However, if you have more than two previous marriages, you're going to want to list the answers to all these questions on a separate sheet of paper. The self-help forms that the circuit courts put out have very specific formatting rules that make them proper to use in the Wisconsin e-filing system. So you'll see this at the bottom of every page of one of these forms. Don't modify the form. If you don't have room to fully answer all the questions, you put it on an additional sheet of paper. You can use as many additional sheets of paper as you want, but don't, some people are really good with Adobe. Don't go in and try and take out the instructions and alter the margins and put more room in so you can type it all neatly here. Put it on a separate sheet of paper, clearly mark what question you're answering so that the people who are reading the documents can understand easily and quickly because they see a lot of these. So just don't alter the form. If you need more space, use an additional sheet. So question number 6, this is the respondent's first marriage. Again, just do the best you can. You may not know, or you may suspect that there were previous marriages that you didn't know about. Just fill it out to the best of your ability. And if you know about more than 2 previous marriages, again, just answer all the questions on an additional sheet of paper. Once again, this is a petition for divorce with minor children. So any child 17 or younger that was either born of the marriage or adopted before or during the marriage are, and then you need to list them. So these are the minor children, 17 or younger. Then the form will go on to ask you about any adult children, so 18 or older. Go ahead and list them. And then there's kind of a catch-all. Any other children born or adopted during this marriage by either party. Just clearly identify who they are, when they were born. If one of you has had a child that might not be with your current spouse, you need to let the court know if there's been a paternity action for child support. Paternity can be established by court order or an order for genetic testing. These are different forms though. But if there's something pending in your county or another county, you're going to need to provide that information to the court. So then the court wants to know about the residency of the minor children. Have they been in Wisconsin for 6 months or more with at least one of the parents? Answer that. Tell the court where you're living. Tell the court where the minor children have been living. And if you need more space, it doesn't tell you you can do this, but you can always put additional addresses on a separate sheet of paper and attach it to your petition. They just want to see with the parents during the past 5 years. So if they've had more than 3 addresses in the past 5 years, do that additional sheet of paper. They also want to know if currently or during the last 5 years, one or more of the children has lived with a person other than a parent. So that would be something like, things are rough right now. The kids went and stayed with grandma and grandpa for 3 months. Well, I worked some things out. Just be very clear, be very specific. They don't ask for a reason, just locations. So question number 8, I personally have been, or I am aware of others who have been a party, witness, or participated in another way in other past court proceedings concerning the paternity, custody of, or physical placement or visitation with the minor children listed in D1 or D3 in Wisconsin or any other state. So D1 or D3, moving back up to look at those. So D1 would be the minor children you have together, either born or adopted. And D3 would be other children which may or may not be a child of yours. Because remember, this is the one where they're asking about other children really born during the marriage, but still possibly outside the marriage. So moving back to this question, and if you don't know, you don't know. You may have heard things, or it may be your child. If so, give the court the information. So question number 9, I am aware of a proceeding that could affect the current proceeding, including proceedings for enforcement and proceedings related to domestic violence, protective orders, termination of parental rights, or adoption concerning the children listed in D1 or D3 in Wisconsin or any other state. So if there is, for instance, a protective order that you or your spouse filed relating to the protection of the minor children of the marriage or the minor children from outside the marriage, you need to give the court that information because they want to take a look at it. They want to know what's going on. And it could be, you could be living currently in La Crosse County, and this could be something that happened down in Milwaukee County. And you just need to be very honest with the court. Don't hold anything back. If you know about a proceeding, if you started a proceeding, you share that information with the court because they will find out. So be as clear as possible. And again, if there's more than one, you can always put it on an additional sheet of paper because they don't really give you a lot of room here to sort of explain what's going on. Or the answer could be no. So number 10 is a really important question. The court likes it when parents come to their own agreements because they just find that it's just a lot more livable for everyone. And, you know, people tend to enjoy sticking to an agreement that they had a hand in making as opposed to just having someone else tell them what to do. So if there are some, even if they're just temporary custody agreements, or you and your spouse have talked about a division of assets or custody and visitation of the minor children, things like that, even if it's informal, go ahead if you have one and attach a copy to the petition if you have one. If you don't, that's okay. It's not required that you have one. But if you have anything, any kind of agreement or temporary idea on what you guys want to do for basically splitting everything, attach it to the petition. So here's the part where you ask the court to grant you a judgment as requested. And the court will want to grant the judgment and enter any other orders it deems just and reasonable. And then you have your big warning. This is all a big warning. And this is how the court expects you to behave, because it's the law, once you file this petition. It's almost like I wouldn't call it an injunction, but just a warning. You're not supposed to harass or abuse your spouse or the children. You're not supposed to start moving assets like encumbering. Don't take out a home equity line of credit on the marital home. Don't sign the title to your sports car over to your girlfriend. Don't drain the joint checking account and give the money to your parents to hold for you until after the divorce is done. That kind of thing. Don't make any big financial moves. You can get necessities. You can do the usual course of business like paying bills, if you have a business, running the business, as long as it's separate. And, you can use your money to pay the reasonable costs and expenses of this action, including attorney's fees. But anything other than that, anything that looks like you're trying to saddle your spouse with a bunch of debt or hide assets, don't do it. And because there are minor children, you're not allowed to just file for divorce and then move to South Dakota. As long as this is in play, this divorce, you can't go more than 100 miles away from the other party without consent of the other party or a court order. Now, emergencies happen, which is why they put in court order. But you're going to be in your area or no more than 100 miles away until this is all finished. You can't take a minor child of the parties out of state for more than 90 consecutive days without consent of the other party, and that should really be in writing or an order of the court. So again, while you're getting divorced and custody and visitation and support are all being worked out, you're not going to move out of the country for 6 months for your job. You're not going to remove that child for an extended period of time until the divorce has been finalized and you've got permission from the court to do it. This is a big one. You can't hide the kids. Barring exigent circumstances where you're asking for a protective order because the other party has been abusing the children, which should have already been shared with the court earlier. You can't hide the kids. You can't say they're not around. They can't talk to you on the phone. You can't come pick them up for lunch. You can't do any of that. You have to work with the other parent to continue having those family relationships. And again, you get another warning. A violation of the above prohibitions may result in punishment for contempt, which can include monetary penalties, imprisonment, and other sanctions. But there's a little caveat here at the bottom. A violation of paragraphs 3, 4, or 5 above is not contempt if the court finds the action was taken to protect a party or minor child from physical abuse, and there was no reasonable opportunity under the circumstances for the party to obtain an order authorizing the action. So, as we discussed earlier, if you find out your spouse was really hurting your kids and you had to move quick, you can do that, but you better be able to prove it. And another warning, these prohibitions apply until the action is dismissed, a final judgment on the action is entered, or the court orders otherwise. So this is interesting. They want you to sign this in front of a notary. If there weren't minor children, they don't ask for a sworn statement, but because there are other people involved, other than just you and your spouse, you do need to sign it in front of a notary. So you'll see your signature block here on the right. Don't sign it until you're in front of a notary. And then here's the signature block for the notary. Now, a lot of people seem to not know where to find a notary. If you belong to a bank, a lot of the time, the bank will provide that service to you for free. You just have to make an appointment. And they don't read your whole document. They just verify what your document is and that you're the person who's signing it. So, again, you can prepare all the way up to this stop sign. And then you have to wait. Don't put anything else here. Just do all of this in front of the notary. And a final reminder, this form shall not be modified. Again, we've touched on this a few times. Don't modify the form. It's in a very specific format that is appropriate for the Wisconsin e-file system. If you modify it, you're going to have to do it over. You can supplement to your heart's content with additional pages. You can put all the things you need to say, if you don't have room on the form, on the additional pages that you prepare yourself. This petition, because it deals with minor children, talks about the child support standard. And I'm not going to go through every paragraph, but it will give you the laws that have been designed to protect children, what the standard child support calculation is, and additional resources. This child support, always think of it as it's for the child, it's not for the other spouse who has the kids with them most of the time. Child support is always for the children. It is a separate legal determination from custody and visitation, and it stands on its own. So if you feel like child support is going to be some kind of a huge issue, or that perhaps your spouse may be dishonest when it comes to providing the legal information required for child support, that would be something you'd want to hire an attorney on, because that's getting into some nitty-gritty legal issues here, complex issues that affect more than one person, obviously. So if you feel that you don't understand the child support standard, or you feel that your spouse may really try to evade child support, that would be something to consult with an attorney on. And that is the petition for divorce with minor children, also called Form FA-4108V. If you're concerned about divorce with minor children in Wisconsin and you'd like to talk to an attorney, or you just want to learn more, you can go ahead and visit our page that's linked below. You should be sure to leave any questions you have in the comments section, and you can subscribe for more legal content daily. Once again, this video was strictly for educational purposes, and it's not legal advice. If you don't understand the process, if you feel overwhelmed, or if you just want to have a sit down with an attorney, you should schedule a consultation with a Wisconsin family law attorney. Thank you so much for watching.
Hi again, this is Kevin O'Flaherty from O'Flaherty Law. I hope you enjoyed the video and podcast. If you did, I'd love it if you'd subscribe to our channel. If you need legal help in this or any other area of law, please don't hesitate to reach out to schedule a consultation. Most consultations are free and can be conducted remotely if you'd like. You can email us, book online, or call us at 414-253-2080. That's 414-253-2080. We have many locations for your convenience, and we serve all of Wisconsin. Thanks again for watching.